Hey guys, welcome to our fourth video in the series on reviewing the text of the Fair Debt Collection Practices Act, the FDCPA. Just as a quick review, in the very first video we looked at why did Congress pass this law. The second video we looked at the list of definitions. And in the last video that we did, we talked about when is a debt collector allowed to talk to or communicate with a third party in looking for location information. Now in this video, we'll look at Section 1692C, which is just sort of general communication in connection with debt collection. So if we look at the subsection A, it says, all right, when you're communicating with the consumer generally, then it says, unless you have permission, you cannot communicate, and then it gives us three things here. Number one, at an unusual time or place that the debt collector knows or should be known to be inconvenient to the consumer. And then it says, unless you know anything differently, assume that it's convenient to talk to somebody after 8 a.m. and before 9 p.m. local time where the consumer is. So what does all this mean? Well, if a debt collector knows that you do shift work, for example, and you sleep from, let's say, 7 a.m. to 4 p.m. and then you go in to work, and you tell them that. You say, look, don't call me during the day because I'm asleep, and you wake me up and it's terribly difficult to go back to sleep. And they call you, then they have violated this section. If you say, I had one case where my client was literally in the hospital, his wife was delivering a baby, and they were having some complications. And the debt collector kept calling him. He said, look, don't call me for the next few days. I'm in the hospital having a baby. Debt collector kept calling. We sued for that because the debt collector knows that's not a convenient time. So this is a very powerful section. I mean, we don't normally see the debt collectors calling before 8 a.m. or after 9 p.m. Unless they're just confused on the time zone. Maybe you used to live in San Francisco and now you live in Birmingham, Alabama, and the debt collector doesn't know that you moved. But once they know, they're pretty good about not calling, outside those normal time periods. But just keep in mind, if you tell them, look, don't call me during these hours or for the next few days because of some legitimate reason, then they need to follow that. Now the second one is, what if the debt collector knows that you're represented by an attorney? Well, then they don't need to be calling you unless they've reached out to the attorney and the attorney doesn't respond in a reasonable time. And then number three, this is a really important one. It says, at the consumer's place of employment, if the debt collector knows or has reason to know the employer prohibits the consumer from receiving such communication. Look, almost every business says you're not supposed to take personal calls. And so if you're at work and you're getting a call on your cell phone or on your work phone and you say, hey, look, I'm not allowed to receive these types of calls while I'm working. Don't call my work number. Don't call my cell phone number because I'm working from 8 to 5. Well, then if the collector continues to call, then that would violate this because it would be both this subsection 1, a time they know it's not convenient, and subsection 3, where they're calling you on your work number and you've told them you're not allowed to get these kind of calls. And so those would be instances where you could sue. Now let's look at the section B. It says communication with third parties. And so it starts off referencing us back to the previous video, which is that acquisition of location information, 1692B. It says except as provided there, and unless you have the consent of the consumer given directly to the debt collector. So it can't be, well, you told the original creditor or you told two debt collectors ago they had permission to call somebody. No, it's got to be directly given to this debt collector. Then it says a debt collector may not communicate in connection with the collection of any debt with any person other than the consumer. Remember, go back to the definition. Consumer is somebody, natural person who owes or allegedly owes a debt. His attorney, a consumer reporting agency, if permitted by law, the creditor, the attorney for the creditor, or the attorney for the debt collector. So notice what that does not include. It does not say they can call your mother or your ex-mother-in-law or your ex-wife or your neighbor or your preacher or anybody else. It's communicate with you, the consumer, with your attorney. And we'll see in another section it also includes your spouse. Okay, so now let's look at something that comes up quite a bit, which is what is often called a cease and desist letter, and this is subsection C. And so let's look at the language very carefully, because it says if a consumer notifies the debt collector in writing, so we're not talking about verbal here, we're talking about in writing, that the consumer refuses to pay a debt. So if you tell the debt collector in writing, I refuse to pay the debt, then they have to follow this subsection. Or that the consumer wishes the debt collector to cease further communication, the debt collector shall not communicate further with the consumer except, and then it gives us some reasons. But before we get to those exceptions, this means if you send a letter that says, I refuse to pay this debt, that is the same thing as a cease and desist letter. So if you say to the debt collector in writing, do not communicate with me anymore, cease all communication, or I refuse to pay this debt, that's all the same thing. The debt collector is not allowed to communicate with you anymore. Now, we get these exceptions. Number one is to say, hey, we're not going to communicate with you anymore. Number two, we may do some other things. So in other words, we might sue you, or we might continue to credit report. So yes, we're going to stop calling you and writing you, but we'll do this other stuff. And then number three is just to say, hey, we are going to invoke this other remedy. So the difference between 2 and 3 is 2 is we may do this, and number 3 is we are invoking this other remedy, like we will be suing you. And then this little section here right above the D just means once the letter is received, then the collector is notified. So really important if you do this sort of stuff, send it by certified mail, send it by FedEx, send it by something where you can track it to make sure, because otherwise the debt collector, if they're the type that's going to break the law, they'll just lie about getting the letter. If it comes in regular mail, they just throw it away. I mean, if we're dealing with a company that will completely violate the law, why would we think that they would be hesitant about lying about getting a letter that you can't prove that they got? So make sure you can prove that they received it, send it by certified mail. Now this subsection D, consumer defined, says for purpose of this section, which is 1692C, collection communications in general, the term consumer means the consumer's spouse. Now notice that is not your ex-spouse, it's not your fiance, it's not your boyfriend, it's your spouse. Parent if the consumer is a minor. Well, what does that mean? If you're not a minor, then they can't contact your parent, which they love to contact parents. A guardian, executor, or administrator. In other words, what this is saying is, look, a consumer is you and your spouse, unless you're in need of some type of assistance. So if you're a minor, you can't make legal decisions, so they can talk to your parent. If you are under a guardianship, or if we're talking about the estate of somebody, then we'd look at the executor or the administrator. So that is this section, 1692C. And a couple of key takeaways here. One, if the debt collector knows, mainly because you've told them, that certain times are inconvenient and be, legitimate, and we don't want to exaggerate things here, but if you say, look, I cannot take calls, or it's really inconvenient to take calls during X period of time, then they need to honor that. Or if they know you have an attorney and they still contact you, that violates the law. We talked about the cease communications here. If you say, don't write me anymore, don't call me anymore, or if you tell them in writing, I'm not going to pay this debt, then they can't contact you anymore. Now, they can still do other things. They can still sue. They can still credit report, but it means they have to stop communicating directly with you. And so I hope that this is helpful. We'll go on to the next section in our follow-up video, and then we'll start getting into the actual sort of list and descriptions of what is abusive or unfair or deceptive type debt collection. So if this is helpful to you, feel free to hit the like button, subscribe so you'll get notified of future videos, and definitely leave me any comments or suggestions, and we'll keep plowing through this very important law that affects us not only when we're talking about kind of normal debt, maybe an old credit card, but as we've talked about in other videos, this can really be helpful if you're dealing with a mortgage company, because so often your mortgage company is considered a debt collector. And when they start lying, they start doing things that are unfair, the FDCPA can be incredibly powerful to sue them, to get damages, and also to get them back on track where they stop breaking the law and stop abusing you. So thanks for watching this video, and I will look forward to seeing you in the next one. Bye-bye.